I'll just start by introducing Migrant Justice Institute. So we are a national research and policy organisation that's dedicated to ending migrant worker exploitation in Australia. It's led by academics and is very academic in orientation, by me at UTS Law Faculty and my colleague Basina Farbenblum, who is at UNSW. And we are seeking to drive, really our focus is on law and policy reform through research, and we've done surveys and interviews of over 15,000 temporary migrant workers in Australia. That has resulted, we're very pleased to say, in some changes and policies and new legal services for migrant workers in New South Wales as well. We do our work drawing on connections across migrant communities, government, business, service providers, unions and the community sector, and so it's wonderful to see all of you today. So just a very short outline of what I plan to talk about today. I want to just start with, and a lot of this will not be new to many of you, but sometimes even though we know that this is the case, what we try to do is to document and sort of provide hard evidence of what we all know is happening and the experiences that people are having, again, in order to kind of press for the urgent need for change and to lay the groundwork for what some of those changes should be. So I'll just start by talking about the evidence that we've gathered on exploitation and barriers to access to justice for migrant workers in Australia. And then I want to turn to some really historic law reforms that have literally just come into force this month. And I also want to talk about the work that is still to be done and why that is. And I want to sort of foreshadow further law reform that's coming in, we believe, next week, which is a new federal a pilot of a new visa that is designed to protect against exploitation and to enable people on temporary visas or who no longer have a visa to take action when their employer does the wrong thing. And so I'll talk a little bit about that. And then, this is a proposal that we brought to government and they've indicated they will be introducing, hopefully, at least to some extent next week or in the coming weeks. And I want to make the case for it and the benefits that it will bring, we think, to migrants, of course, and communities, but also to business and government and others who are committed to addressing exploitation and modern slavery. But I also want to make the case for how critical it is that these reforms do extend to palm workers and people who've disengaged from the scheme as well. And I'll end just by foreshadowing some of our upcoming research. So the PALM is the Pacific Australia Labour Mobility Scheme, in which seasonal workers from the Pacific Islands and longer-term workers are working in a range of industries, including agriculture, meat processing, but also tourism, aged care, and a range of other industries as well. So it's a part of, it's certainly the part of the immigration program that's dedicated to seasonal work, and that is dedicated to providing a workforce for seasonal work. But I guess what our research has sort of showed, and what I think many of us know, is that there are workers on a range of temporary visas in Australia who are doing all sorts of work that are on visa programs, not necessarily, where I think the Australian community perhaps thinks we don't have, a guest worker program, we don't have large numbers of migrant workers. But in fact, we have around, I haven't kept up with the latest stats, but it's probably almost 700,000 now, 600 to 700,000 international students alone. And well over 1 million people, excluding even New Zealanders. So New Zealanders can come and work in Australia on a temporary visa. But even excluding them, there are backpackers, international students, people who are working in skilled or jobs who are sponsored by their employers, Pacific Islanders who are working in the PALM scheme, people who have just come on a tourist visa or overstayed a visa, and there's at least around 100,000 of them who are continue to work and live in Australia as well. And so I guess we set out to kind of demonstrate to Australians and to the government that we have a lot of migrant workers working here, and they do not sort of always work and enjoy working conditions that conform with Australian law. So around 1 in 4 of the thousands of workers that we surveyed indicated that they earned half the minimum wage or less. 3% of migrant workers in one survey that was of over 4,000 people said that their passport had been confiscated. 3% said that they, someone, either their boss or supervisor, had threatened to report them to immigration and get them deported. 5% indicated that they had paid to obtain their job, which is not lawful in Australia. And I think, and among them, not only did we, did people sort of share these experiences, but there is a perception among people on temporary visas that exploitation is ubiquitous as well. So over 3/4 of all of the migrant workers who answered our survey said that they believed that many, most or all other migrant workers on their visa were not being paid the minimum wage as well. And often sort of the government and others or businesses will say, well, it's because it's because migrants don't understand the system, they don't know their rights. But in fact, we asked workers what the minimum wage was, and the vast majority knew that they were being underpaid. So it's, there may be some knowledge gaps about the sort of greater complexities of our employment laws, but it's not the case that people don't understand what's happening at all. So as I mentioned, we then asked in detail what workers did to address the underpayment. And I just want to sort of flag that, clearly there are far more serious forms of mistreatment or exploitation than just being underpaid. But we did focus on we have focused on underpayment alongside other working conditions. Just to start with a problem or complaint that is concrete and straightforward, and I think what we've said to people who are sort of in the modern slavery community and our businesses who are trying to ensure that modern slavery is not occurring in their supply chains or in their operations, we've said that if migrant workers are not seeking help for just a garden variety underpayment of their wages, or they're not reporting that, then there's no way that they are going to report or even seek help for experiences of criminal forms of exploitation. So we feel, and we have been told, that this is a sort of an important way into this problem, even though it's limited and it is only a part of the very many problems that people face. So, yes. So onto our findings. So among those people who knew that they had been underpaid, we asked them what they did. Did they seek any help or take any action? And 9 in 10 workers who knew that they were not being paid properly said that they took no action to recover wages. And when we asked why they stayed silent, more than 1 in 3 international students, in one survey that we did of international students, and you'll see we, as a sort of large proportion of migrant workers, we have at times focused on international students as a group. So many international students pointed to their fear of jeopardising their visa, and I'm sure that this is sort of an issue that many of you will be very familiar with. So we know, and I think you know, that non-reporting is not just a factor of lack of information or even language barriers or lack of understanding the foreign legal system. And we found underpayment rife in our earlier surveys among British backpackers as well, who speak the language and may have some, maybe working in a country that's perhaps more familiar to back home. But they were getting underpaid too, and they also didn't do anything about it. So even though they are some impediments, like our data shows fundamentally, and again I think many of us working in this space all know that migrant workers don't report exploitation or seek remedies because it's just not rational to do that. The risks to their immigration status and their ongoing stay in Australia and their job security, of course, as well, and the costs, the time and effort that it takes, and the difficulty of trying to seek help and engage a remedy are all very high. And the chance of any positive thing coming out of it at the end of the day is very, whether it's a penalty for the employer or a remedy, actually getting compensation for the actually getting back the wages that you were owed, the prospect of all of that is very low. So it doesn't, so that's why people aren't doing it, because it doesn't make sense. And when we asked all of these migrant workers then, again, these are ones people who knew that they were underpaid, whether they would be willing to address the underpayment. We were actually surprised. We thought that there might be a reluctance for all of these reasons, but the vast majority said that they are willing to do something about it. And so I guess that really kind of suggests that the condition that's, now on the Australian community and the government and businesses to make sure the conditions are right to enable migrant workers to do that. So again, what migrants are open to reporting but don't report, due to this rational calculus that on the one hand the risks and costs of reporting are very high. It is also that the system, it just isn't working to enable migrant workers to get a remedy or to address their exploitation in some satisfactory way. And that's the case. So a remedy is remote even for just a straightforward claim like an underpayment, much less something much more complex or, traumatic. So only, again, when we asked all of these underpaid migrant workers if they did anything, we said 9 in 10 said no, but they didn't. But we asked them, the 10%, the 1 in 10, what they did. And basically only 3 out of 100, every 100 underpaid migrant workers, so 3%, said that they'd approached the Fair Work Ombudsman for help to try to recover their wages. And among those who did, we asked them what happened, and the vast majority said that they got none of their wages back. And we know that in the first prosecution for forced labour in Australia, which was some years ago now, the migrant worker was on a sponsored 457 visa at the time, which is, a visa that is sponsored by their employer. And that person who had gotten a conviction against his employer for forced labour was actually turned away by the Fair Work Ombudsman for lack of evidence, and had to pursue labour remedies in court through a pro bono firm, which then actually recovered over $100,000 for that worker. But then in our survey, again, when we asked what people did, one single worker in 4,300 that answered, participated in our survey, one single worker went to a court and they recovered nothing as well. So again, migrant workers' silence is a rational calculus, that the potential benefit of reporting just doesn't outweigh the risks and burdens that are, significant of taking action. And then, compounding that, this is for years for undocumented workers, so these are people who have overstayed their visa, including people who have disengaged from the PALM scheme. And I'm a lawyer, so apologies, I'm going to get into a little bit of the law now, but so case law in the courts for years has been unclear as to whether those people who are working without a visa or in contravention of their visa, they're working more hours than they're allowed, or they're working for someone and that's not their sponsor, so they've breached their visa. The courts have said for years that it is unclear whether those people are even legally working, in work, and they may not even have a legal entitlement because they're not legally speaking employees. So for decades, it has actually been a criminal offence to undertake undocumented work in Australia. And because these people, including disengaged migrant workers, workers from PALM, who've left the scheme and are out working on their own, it's actually a criminal offence. It has been a criminal offence because they're working illegally, because they are actually engaged in a criminal offence, although they may have no idea. Various courts have found that those work contracts, those employment contracts, are void for illegality because it's like a criminal enterprise. And so the rights and protections flowing from employment law, and under broader labour laws were void too. So basically, long story short, if you have not been following all of the technical legal analysis here, basically the courts have said that if you are working in contravention of your visa, or you don't have a visa anymore and you are undocumented here, you have no right to workers' compensation, notwithstanding any injury that you might get at work. That you have, you are not subject to minimum wage laws in Australia that apply to employees because you're not an employee. And under the law, because you've breached your migration rules. And as I say, that includes people who have disengaged from PALM and are no longer working for their designated employer under PALM. It also includes international students, as I said, and of which there are hundreds of thousands, and many of them do work more hours than are permitted. They're allowed to work 48 hours a fortnight, and many of them are working more, especially if they are actually being underpaid as well and earning half the minimum wage. So, this is all just to say that the benefit side of the ledger is frequently sort of insubstantial and remote, and migrant workers are getting the message that their breach of immigration laws actually voids all protections and entitlements. And on the risk side, as I mentioned before, we know that fear of jeopardising visa or a future immigration pathway for many international students who want to ultimately become residents in Australia, all of that is enough to stop people from reporting. But I do want to just very quickly break down some of the specific concerns for different cohorts, because that's the case for migrant workers on employer-sponsored visas. If they speak up or even try to complain to their employer, if their employer lets them go, then they lose their right to obviously the job and to remain in the country. International students, as I say, may be working in breach of their visa conditions, and so they're afraid that if they go to the Fair Work Ombudsman or they go to a lawyer, or somehow someone might tell immigration, and they their breach of their visa condition will be detected, and then their visa will be cancelled and they'll be deported back home. And obviously undocumented workers, people who've come on a tourist visa, say, and overstayed, may be the most vulnerable to modern slavery, and they're also afraid that if they come forward and seek help, then they will come to the notice of immigration and they'll be deported. So none of those workers are going to report. And again, this is, apologies, I'm sure this is a lot of stuff that we already know. But I just wanted to point out that what we found that we were even surprised about that people may not know is that fear of visa cancellation goes further. It's not just that people know that they're breaching their visa or that they might lose their sponsor and so they might put their visa at risk. There's actually a range of sort of misconceptions that people have about what is illegal and what might put their visa at risk. So 4 in 5 migrants, for instance, in one survey that we did, wrongly believed that they were breaking the law if they accepted an underpayment. So if they took a job for $15 an hour, which is unlawful, that the employer is not allowed to pay that little, but they believed that they were actually somehow breaking the law as well, and that could lead them to lose their visa if it came out. Around 70% of migrant workers wrongly believed that they broke the law by accepting wages in cash and taking on a cash job, when in fact that is not illegal for anyone. It's perfectly fine for an employer to pay someone in cash, and it's fine to get wages in cash. And just when we asked international students, 82% wrongly believed, we were looking at international students and housing, and the vast majority thought that if they didn't pay their rent or somehow breach their tenancy, that could lead their visa to be cancelled, none of which is the case. And so we feel that these migrant workers' sort of misconceptions about their culpability that lead them to wrongly believe that they may be in breach of their visa even when they're not, and that sort of adds a whole other layer of not wanting to seek help or report exploitation. And so again, that sort of suggests that the reforms, then if we're thinking about government policies and laws and business practices, that we need to target are sort of reducing the barriers that create the risks and costs for migrant workers of taking action, including addressing some of these misconceptions as well, and then improve the on the other side of the ledger, improve the effectiveness of avenues to wage recovery, and addressing other sorts of abuses as well, including in the Fair Work Ombudsman, in the courts, and other areas of redress. So the federal government came into power, this federal government, the Albanese government, came into power with a commitment to implement recommendations from the Migrant Worker Task Force, which had looked into this issue several years ago and had made a range of recommendations for reform. many of which that were addressed are trying to change this calculus. But some of that, we've just this month seen changes that are some of the most significant changes we've seen in Australia to address migrant worker exploitation. So, as I said before, all of the sort of the court's decisions around the fact that undocumented workers aren't covered by labour law, that has all been changed. So it is no longer a criminal offence to work against, not in conformity with your visa. And undocumented workers, including workers who have disengaged from PALM, are now protected under all workplace laws, minimum wages, sexual harassment, discrimination in industry. So regardless of whether they were working illegally, they still have rights as workers. They might have immigration issues, but they, have rights as workers. And it's no longer a crime to work in breach of the Migration Act. And so we're hoping that will actually go some way to addressing some of those feelings of complicity as well, especially among undocumented workers. It is now also a crime for employers to use threats of immigration consequences to coerce migrants into breaching their visa or accepting bad working conditions or living conditions. And businesses that exploit migrant workers may actually now be added, and I don't know if the mechanics of this has been set up yet, but there is a new prohibited employer list, so that if you have been found to exploit migrant workers in the past, you are barred from employing migrant workers on visas in the future. So that's increased the penalties, that employers face. But more is still required, we think, to make it, again, rational for migrant workers to report underpayment and, more serious criminal exploitation as well. The government did introduce more, again, only just 2 weeks ago, but only for a limited group of migrant workers. So there is now a new sort of mobility scheme for temporary skilled shortage visa holders. So these are people who are on a skilled visa sponsored by their employers. They now, previously, they could leave an employer, but they had 60 days to find another sponsor before their visa would come to an end. They couldn't do other work in that time. So that's now been changed to 180 days, 6 months, after leaving one sponsor to find another sponsor before otherwise their residence permit terminates. And they actually, in this 6 month period, I think what's critical is they can work for any employer now, which is, it's going to make a huge difference. And they can work in any occupation for any employer while they're trying to find another sponsor. And they can do that for a total of 365 days during the course of their visa. So they can do it again. Once having done it, they could do it again down the track. And we really hope that, we think this is really wonderful and will hopefully go some way to shifting the power imbalance between sponsoring workers and employers, so that migrants can walk away now without risking their stay in Australia more, and knowing that they can find some other work to sustain them while trying to find another sponsor rather than they need to support themselves on their savings alone. But critically, this new protection does not apply to PALM workers. It doesn't apply to Pacific workers working in the industries, under the PALM scheme. So obviously much more is needed there. So I just want to talk about some other, I guess this all sort of sets the groundwork for the work that we've done about, what more is needed here. And I'll come in a moment to what we have said should happen that would again go some way to addressing this. Yes.
One big question: why aren't workers covered by these changes?
That's a very good question that you'll need to ask, I think, the Department of Employment and DFAT and the Department of Home Affairs. I'm sure they'll provide a detailed answer to that, but I don't think it's not that it's not possible to do it. There's been a decision made not to extend that. Yeah. So I'll just take one other little step back before kind of moving forward. I just want to sort of point out just one other attempt that was made in this space to address these issues. And so I just want to talk about the shortcomings of previous interventions here. So the Fair Work Ombudsman, which is the National Labour Regulator, and the Department of Home Affairs, or the Immigration Department, together established in 2017 what they called an assurance protocol. And it was, I think, in principle, an extremely innovative approach to reducing these negative like visa consequences for migrant workers who come forward. So this was an MOU, an agreement between the departments where immigration said that they will exercise their discretion not to cancel a migrant worker's visa if the Fair Work Ombudsman is making inquiries in relation to that worker and the complaint. So, it's a sort of like, what in some other places is called a subversion of a firewall, but it was a commitment that if you go to the Fair Work Ombudsman, if the Fair Work Ombudsman, it starts to investigate your claim, then Home Affairs won't cancel your visa even if you've breached it. But it was unfortunately, and I think the government recognises this as well, ineffective. So between 2017 when it was established, and I have the latest figures of January this year, it was used by only 94 migrants, where you would think that probably, again, there's hundreds of thousands of temporary visa holders who might have had a work complaint and might have breached their visa, over that period of time, but only 94 used it. So why did that fail? I think there's a range of reasons. One is that the Fair Work Ombudsman doesn't pursue most complaints. So it takes a strategic approach to enforcement, and just because you go and ask the Fair Work Ombudsman for help doesn't mean that they're going to, inquire further into your matter, or that's not going to trigger an investigation. Which is what the threshold that was required. The Fair Work Ombudsman, decides that it will focus on particular industries and particular types of breaches, for good reason, and it, in line with its strategy, and obviously has limited resourcing as well. But so, it's not the case that if you go and ask the Fair Work Ombudsman for help, you know that your visa is secure. Another reason is even if, even with the best will in the world, most migrant workers would never go to the government department like Fair Work Ombudsman anyway to seek help. So, and it was only available for people in who, FWO was assisting. So there's no visa protection for anyone else. Also, the Fair Work Ombudsman's remit, it extends to underpayment and some other sort of employment law breaches, but not to workplace health and safety, not to sexual harassment or injury, and so there was no protection for reporting those problems. Again, it was only people who went to the Fair Work Ombudsman. So if a migrant worker wanted help with one of those problems, or wanted to, work with a union or with a lawyer outside of a union to pursue their claim, there was no protection for them. And finally, also I think part of the problem was that this whole arrangement was just an agreement between the departments and was something that was on the website. It actually wasn't set out in law anywhere. So some lawyers felt they had to advise their clients not to rely on it because, there was no actual technical legal right there. Finally, because this scheme was open to people, Pacific Islander workers in the PALM scheme, it insulated the workers' visa from being cancelled just because they'd breached their visa. But if the outcome of the investigation was that the employer was found to have done the wrong thing and their ability to sponsor a worker is sort of cancelled, then the sponsorship is terminated and those workers lose their jobs and no longer have a sponsor, and actually they are now also, sort of at risk of losing their visas, and there was no provision for that. So the Migrant Worker Task Force had recommended sort of revisiting the scheme. Hang on, I'm going the wrong way. So the Migrant Worker Task Force did suggest that there be work done here, and the Albanese government and Immigration Minister Andrew Giles came in and said that they want to do something, that they recognised that the assurance protocol was not effective and were committed to doing more. And so in the context of that, around 2022, after the election of that government, And based on the research that we'd done, we and others developed a blueprint for what we see as a real, like, world first new visa scheme that would enable migrant workers to safely speak up about their abuse and underpayment and enforce their rights without risking deportation. I'll just pause here briefly because we looked for overseas examples that we could draw on, where governments overseas had addressed migrants' visa fears. And the best, and we did come up wanting, I have to say. I don't know that anyone is doing this particularly well, but there have been the best visa schemes that we found, which are, certainly strong, are in Canada and New Zealand. Those schemes enable portability for migrant workers who are exploited by their employer sponsor. So the New Zealand scheme, which is the Migrant Exploitation Protection Work Visa, so it's for migrant workers who are have an employer sponsor. It's sort of similar to our skilled work program. They can apply if they need to leave their employer. They can apply for a 6-month visa to do that, to sort of and work anywhere, and then find another employer sponsor. But I have to say that is now what we've kind of superseded that, I think, in this 180-day new scheme. I think our scheme for skilled sponsored workers is now better because you don't even need to apply for a visa. You don't need to show you're exploited. You can leave an employer if you're employed by a sponsor in the skilled program for any reason, and then work for 6 months before finding another sponsor. So in New Zealand, you have to apply for the visa and show that you're exploited. So I think our mechanism is now better than theirs. The Canadian scheme, it's called the Open Permit, the Open Work Permit for Vulnerable Workers. So that's a 1-year sort of visa for agricultural workers. So this is more like for Pacific workers here working in agriculture and other industries. And that the Canadian scheme provides safeguards against exploitation. So in the context of an agriculture work program there, that again is more similar to our PALM scheme. But that scheme, while it applies to agriculture workers who are sponsored, who can get a year visa if they demonstrate they're exploited and work anywhere. It doesn't apply, it's not available for undocumented workers, so like disengaged workers, and it doesn't also sort of apply to international students or other people who are working on their visa, and who might not take action because of their breach of their visa. And I should say the objectives of both of those schemes in the US and Canada are portability, to avoid exploitation, which is obviously absolutely critical, but those schemes do leave out a focus on enforcement or accountability for employers. So in those schemes, there's no mandatory reporting actually to the Labor Department of abuse. There's no penalties for employers when this happens. There's no redress for workers under those schemes. But it obviously critically does allow a worker to leave a bad sponsor, and try and find another. But our proposal, we wanted to, again, create what really is a world first, which is a temporary visa that enables people to enforce their labour rights in Australia. So under our proposal, we said that it needs to be available, and so there are protections from visa cancellation for mainly international students, and also a new visa need to be available for workers who wish to report and pursue a claim against an employer, not just through the Fair Work Ombudsman or other government agencies, but also through a lawyer or through collective action through a union. It needs to extend beyond the assurance protocol, not just to underpayment, but also all other sort of worker abuse. But it shouldn't be. The Canadian scheme's actually quite high. You need to show a reasonably high level of abuse, and we want it to be accessible for people who might just have a garden variety underpayment. We wanted the protection against visa cancellation. So let's say an international student who's breached their visa, they've worked too much, but their employer has exploited them and they want to do something about it. so that needs, if they're going to be protected and their visa is going to be insulated from cancellation, we've said, and again, others in this room, have been campaigning for this for years, we've said it needs to be available as a guarantee. So from a migrant's perspective, reaching out to the government agency to report exploitation, like even if you have been trafficked and you go to the police and say that you are a victim of trafficking or a survivor of forced labour, it's an entirely speculative exercise. And you can do that, but there's no guarantee that the agency, the police or the Fair Work Ombudsman or anyone else is going to agree with you and say, yes, I recognise you as a potential, survivor of criminal misconduct, and we're going to take up your case. There's no guarantee that you're going to meet the threshold of, forced labour and so on. So we've just said that a worker or survivor must have to approach the authorities without knowing in advance that, knowing in advance that you're going to, you're almost certainly going to get the protection. So you need to know that it's guaranteed, that if you do something about this, nothing will affect your visa. And I guess, and just, we have sort of devised this scheme, again, in collaboration with many, some of you here and others not in this room, hoping that this will not only address workers' visa fears and encourage them to report, but that hopefully it sort of expands the ecosystem of labour enforcement in Australia as well, so that it's not just the Fair Work Ombudsman that takes up these cases, but you've got now all these lawyers and unions able to offer protection as well in taking up the cases. And so that proposal was endorsed by over 40 organisations, including many of those of you in the room today, including the Office of the Anti-Slavery Commissioner in New South Wales and business as well. And so off of all of that, and again, they had indicated that the Minister, Andrew Giles, Immigration Minister, had indicated that they were going to do something in this space, and they committed to implement the two key elements of this proposal. Apparently, it will be announced next week. It's certainly coming soon. They had said that it would commence in July, and if not next week, then very soon. And so I'll talk you through a little bit about so we don't know exactly what it looks like until the announcement is made. I'll tell you what we proposed in a little bit of detail. And interestingly, some British organisations have come to us as well and asked for advice or just to share experiences with their new government as well, whether they might be able to sort of introduce something like this too. So again, there's two parts of this. One is a protection against visa cancellation. So we had said that there needs to be a guarantee, and we understand that much of this has sort of been heard and accepted by the government. We'll see what the final details of this look like. But it's a guarantee that your current visa won't be cancelled if you're on one, and any future application for residence or anything else won't be affected either. International students and other migrant workers who apply for this protection will know that there's this guarantee when they sort of apply. It shouldn't be dependent on the government or a government agency taking up the case. It should be available where a trusted non-government lawyer or, in a community legal centre or a union or maybe a pro bono lawyer certifies that that the migrant worker has a legitimate claim. We were concerned about the integrity of this as well. We wanted to ensure that it's not the case that anyone could just put up their hand and say, I've been exploited, I need a visa. Of course, that's not going to be workable for the government in the context of the immigration system that we have. But that you could get a certification from a trusted third party, not just someone in the community, not just the government, that you have a claim, that you are telling the truth, and that you would get this protection. And that includes even, university legal services here at ACU, say, for international students who are here. And it should be available not just for underpayment, but a whole range of different sorts of claims, and that it should be available for Pacific workers as well, so that if a Pacific worker has disengaged from the scheme and breached their visa, they could go to a union or a lawyer and get a certification if they had been, sort of their work rights hadn't been upheld, and they have a claim against their employer, that a lawyer or union could certify that, and they could take that to the immigration department, knowing that their visa wouldn't be cancelled, and that would allow them to reconnect with the scheme if they wished. So we secondly had a proposal for what we called the workplace justice visa. So this is for someone who's reached the end of their stay, and isn't able to make a claim because their visa is about to come to an end, and this would be a temporary visa for them to take action to enforce their workplace rights. It's similar to a trafficking visa, but again, sort of different. It should be for at least 6 to 12 months, we said. It should have unlimited work rights, because otherwise it's useless to people if they can't work while they're pursuing, and sustain themselves with income in Australia while they're pursuing a claim. And it, again, should be available if you get a certification from a lawyer, union or government. By all means, you should be able to go to the Fair Work Ombudsman, and the Fair Work Ombudsman could certify your claim too. That you've got a claim that needs to be pursued. We said the visa needs to allow you to transition to other visas. So, you shouldn't have less pathways than your previous visa. And it should be available for palm workers and undocumented workers, so that if an undocumented worker, experiences exploitation, they could go to a lawyer or a union, get the certification that they do have a legitimate claim, and then they could take that to Home Affairs and get a 6 to 12 month visa to pursue the claim, and then, sort out what they might do next. And so, so in a lot of ways, it's more accessible and more beneficial than the current trafficking visa, where you need the police to say that you may be a victim of trafficking, and so on. But critically, I don't imagine that it wouldn't come with any government support. So people would need to work while they were doing this, I think, under the scheme that we were discussing with the government. And so we have been involved in this co-design process with the Home Affairs, which has been wonderful. Home Affairs brought together academics like me, but also unions and community legal centres and immigration lawyers and business to sort of try to nut out some of these issues. And I think it's wonderful to see the government sort of engaging in evidence-based policy making, with these sort of tripartite consultations with business and unions and the community. And I think, to develop something, it's a pilot. So I think the government's kind of doing something that's going to could be developed iteratively over the time. It could be improved upon, if there appear to be issues. And that really, I think the government was committed to sort of involving the community and third parties and I guess what they call client perspective, which is people on visas themselves, migrants. And so it is coming. We don't know the final details. Regulations were introduced in the last couple of weeks that set out the framework that indicate that there will be this sort of the ability for there to be a community certifier. So it's not just the government. And we will learn more when it is announced. And I guess, we've been trying to, me and others in this room have been trying to make the case for this for some time. We're, excited. It's certainly not going to end migrant worker exploitation, but we really do think it will shift the dial in some of these ways. Put employers on notice that they can't just exploit people on visas knowing that, if they've worked illegally, knowing that they can't do, those workers will never ever do anything about it. I think now employers might know that they could get a visa and do something about it. Expanding enforcement, I think, beyond government agencies is sort of useful and important. So obviously the Fair Work Ombudsman can continue its investigations, but hopefully now there will be a larger number of lawyers and unions taking up these matters, which will hopefully sort of just ventilate these claims and I think make then businesses and others on notice that, just how much exploitation is happening in the businesses, in the industries in which they're operating. And I think in government, hopefully, we'll gain a lot of intelligence from this as well. And benefits for business, we have said as well in addressing modern slavery, and, in their operations and supply chains in a range of different ways. I think hopefully business can learn from this. They might find gaps. Businesses who are trying to sort of ascertain whether there's exploitation in their supply chains might now sort of realise, oh, there's quite a lot of cases in, you know, in relation to this food product in this part of Victoria, and just have more visibility over the industries and what's happening. And may be able to develop sort of better auditing and reporting and sort of grievance processes by sort of looking at whether and, you know, how this new scheme works and, you know, what's required to sort of set up a scheme that does encourage people to come forward. And so, I mean, there's obviously much more work to do, and that is what, and you will all be, and I, you know, look forward to discussing that in the coming, you know, today and tomorrow. This pilot may not initially extend to palm workers, Pacific Islanders either, just like the 180-day scheme. It may not extend to undocumented workers, but, you know, it's important. It's absolutely. I mean, you know, we'll find out next week, but it's absolutely critical that it come to over time. You know, I think the government said this is a pilot. We're going to see. We can expand it if it's working. I mean, obviously, it's only by ensuring workers who are most at risk of exploitation that, you know, this visa scheme can help these workers do something about it, and, you know, and not be forced to stay silent. And there's going to need to be a lot more work to do, and, you know, I think in all of our communities to promote this, so that people actually know that it's available. And I guess, you know, I just yes, I won't go. I was going to talk about, there were 7-Eleven, you might recall some years ago now, was involved in a huge scandal where there was lots of exploitation in stores around the country, and to its credit, the 7-Eleven head office set up a scheme that ended up repaying those workers. They were mainly international students, and from China and India, over $150 million that those workers were owed. And one of the reasons why that scheme worked, we think, is that they publicised, they did also say, we're not going to tell immigration about your visa, so you can come and do this, you know, anonymously. But also, we're going to tell this when it works, and when we give you, you know, the $30,000 that you owed, we're going to tell the story and promote this through networks. And it was really that demonstration effect, I think, that ended up, you know, because the $150 million worth of workers came and actually reclaimed their wages from the scheme. So I think getting the word out and people having trust in the scheme is critical, so that people know that actually this does work. You don't lose your visa. It doesn't sort of, you know, you end up worse off. In fact, you are able to finally hold your employer to account. And of course, I mean, there'll be lots of evaluation of this scheme too, and you know, I think hopefully improvement over time. So I'll just finish by telling you a little bit about some new research that we're doing that we hope will lay the groundwork for future reforms as well. And just that our approach has been, as I've sort of said, to try and get large-scale data, you know, that I think that we feel that government and business, you know, often find compelling. So it's not just anecdotal stories, although, I mean, obviously stories are critical, but that we can say that, you know, thousands and thousands of migrant workers have repeatedly told us this over time. And we can tell you just how many within you know, among people who we've, you know, participated in our survey. And that has enabled us and other, you know, and working with others to, you know, get things like a new legal service for migrant workers in New South Wales. We were able to sort of feed into the Migrant Worker Task Force inquiry as well, and the recommendations that they were making. And in COVID, for instance, we, and again, some of you here I know, worked to respond to the migrant workers who were locked out of JobKeeper during the lockdowns during COVID. When they lost their jobs, got no government support at all. And so we did another large survey of, you know, to demonstrate just how, you know, vast the financial insecurity was then, and that actually was quietly reversed by the federal government the following year. And so because we have found this effective in the past, we are doing it again. So we're actually right now promoting a new survey that we are conducting. It's the first one we've done post-COVID of all temporary visa holders in Australia. We're asking about problems at work, and, you know, to inform what are the problems, what are the changes that we think might work, and, you know, how do we tailor support programs for different groups of migrant workers, because of course, you know, that the diversity of people and experiences across all, you know, a range of temporary visas is vast. But this one is because I do think that Pacific Islander workers are working in a very different context than an international student or a backpacker. So that survey is very broad and is for all temporary visa holders, but not including undocumented workers, but not focused on Pacific Islander workers, because, you know, I think their experiences are quite different. And so just with that broad, the topics that we're addressing in that broad survey are up there, including underpayment, illness and injury, sexual harassment, and you know, and again, our preoccupation always is not just what are the abuses that people are experiencing, but whether they do anything about it, seek help or report. If not, why not? If they do, what do they do, and with what outcome, again, to really try and then inform what we think could be different here. But so we are also conducting a survey through interviews with Pacific workers as well in August and September this year. We've received funding from the International Labour Organization Pacific office to do that and to focus on grievance processes. So where Pacific Islander workers go for assistance when they need help or to report problems, and, you know, not just in formal avenues, but among community networks and churches and, you know, the entire sort of across the community and society. And are those problems sort of resolved well, you know, in those different networks and looking at different problems. We're doing this research with others, and we hope that this research too will sort of drive evidence-based policy reforms as well, and more tailored support programs for the workers that we speak to. And if you would like to be involved or learn more about either of these things, I've put up my email address. Please feel free to reach out. I'd be delighted to learn from you all and talk much more about what your sort of thoughts and input to this might be. So I think that's it from me. I know it's been a long time sitting, and I just, I focus today on the responsibilities that Australia and the government and communities have for migrant workers who are working in Australia, and that is the work that, you know, you are all doing so that we acquit our responsibilities. But of course, we're also here very much today and tomorrow to reflect on the tremendous gifts of welcoming Pacific Islander workers and other migrant workers to Australia, and the tremendous contribution that people on visas make to Australia, certainly not just in relation to their work, but in, you know, the depth, the rich and deep, like the relationships, community connections, and obviously and spiritual connections that people have while they're here. So yeah, I feel very privileged to be part of this conversation, and open to questions if there are any, but also would love to hear from you if you'd like to share about what your aspirations are for, you know, the work that you're doing and you've been doing, and the aspirations for this conversation over today and tomorrow as well. Or there might be an early break. Yes.
Sorry. Do you know what number Pacific Island farm workers there would be in Australia compared to the other migrant workers?
Yes, I mean we do, and there are others who are probably far better placed than I to give specific response.
About 32,000 workers in the country.
Workers.
32,000. So
About 700,000
look.
migrant workers.
No, there's probably, I think I should have checked before I came. There's more than 600,000 international students, all of whom can work. There are around 100,000, if not more, backpackers here at any one time as well. There are also roughly that many sponsored workers. And then there's no doubt at least 100,000 people who are working who no longer have a visa here. Perhaps they overstayed a tourist visa. And others, I mean, you know, and people who are asylum seekers who are working here, whether they came here by boat many years ago and still have very precarious visa status, or whether they came here by plane.
Well, just without wanting to personalise the story, so I come from a smaller rural agricultural area, irrigation area. So farm workers are our concern, not so much other migrant workers. And I see them as being the most disadvantaged, with the most, often because of language, that can be disengaged very easily by an employer if that's what they seek, or they seek that themselves, particularly women. And I think they need to be represented more effectively and strongly in so it's me not pitting one against the other, but we need to be including them in what to present.
Absolutely. Absolutely. Yes.
Christine Carolyn from ACMRO. Thank you so much, Laurie, and congratulations on the work with government, because I think that where you're linking arms with government and government's linking arms, the federal government linking arms back, is really going to, those visas are exciting.
Yeah.
My question is, every now and then we hear of exploitation of workers within ACMRO, and what I feel like you need is some sort of light touch tribunal, some sort of a system that doesn't mean that a worker says, oh, I only got 14 hours at work last week and I took the average sum of 30 for 4 weeks. They're not going to go to a lawyer. That's too expensive to them, and there may well be 400 of workers experiencing that same exploitative practice.
Yeah.
So have you got any thoughts about light touch?
I think it's the holy grail, actually, a sort of a light touch scheme where people could immediately get some sort of recognition and redress for where their rights have been violated. We have done work separate. I mean, we are lawyers, so I think we do kind of tend to revert to that mindset, but you're absolutely right. And we have done work on the failings of the court system too, so that even if you're not worried about your visa and you go to court, you can, it's very difficult to get redress for wages, much less anything, again, more complicated. And I think that we've sort of then, I can send you some of the work that we've done, a proposal for reform there, and that there be, rather than having to go to court, that you should be able to go to the Fair Work Commission, which is a tribunal. I think it is still, it's probably not as light touch as you would like, but I think at least you wouldn't need a lawyer. And there is more informality we found, and sort of also support for someone who comes without a lawyer to sort of get through the process themselves. But I think that labour laws are extremely complicated. I think that is also part of the problem here. And I think that it would, be wonderful to sort of come up with some more creative strategies for that sort of light touch. And I hope that, you should, under our scheme, you wouldn't be paying for the lawyer. It would also require sort of expansion of community legal services as well, and legal aid, and hopefully pro bono services as well, that would again go some way to, I think, increasing the pool of resources to support workers. Yeah, even just to, and we found, and actually they found in relation to 7-Eleven that even just like a lawyer, but a community lawyer, just writing a letter to the employer saying, hello, I believe, my client's saying that you have underpaid them. I hope that you can make this right. That's actually a very effective way of getting redress, perhaps even more effective than, in some cases, than, if you go to the Fair Work Ombudsman, they may not be able to take up your case because of capacity and other reasons. If you go to the court, it's all very hard. But just, a light, an informal mechanism like a letter from, someone with a little bit of clout, like a community lawyer, not even a lot of clout, can be very effective. Yes.
Sorry, we might have to leave it
okay.
there for the timetable.
Thank you so much for having me, and hopefully some of those questions can be ventilated in the coming days. But I really appreciate it.
Thank you so much, Laurie. And